Andres, I need permission to record.
Sure. Hello, everybody. Welcome. Just getting everyone in the lobby, and then we'll start up the meeting. All right, let's get started. Good morning, everybody, and welcome to our webinar, 3 Easy Steps to Estate Planning. My name is Andreas Altamirano, and I am the Client Services Coordinator for the Greene Estate, Probate, and Elder Law Firm. I would like to start by thanking everyone for being here today. I imagine it may have been a rough month for many of us, but hopefully everyone is staying safe. And on behalf of the Greene Estate, Probate, and Elder Law Firm, we're wishing you the best. Before I start off with the presentation, I just wanted to explain the structure of how today's webinar will work. So for starters, all of you guys are muted, which I'm sure you've realized by now. This is just done to prevent accidental noise or any kind of echo coming from your guys' computer. Nothing personal, of course, but we want to just ensure that Jay will have a smooth presentation and that we won't have any interruptions so that everyone in the lobby could hear everything. So in light of you guys being muted, we still will be chatting. We'll be chatting via the Zoom interface. And for those of you who may be less familiar with Zoom, you'll see at the bottom of your screen, you should have an options menu. And on that options menu should be a chat icon. Go ahead and click the chat icon for me, please. And that should bring up a chat box on the right side of your screen. This chat box will be used for comments that you have during the presentation or any questions you may have. We'll be answering questions at the end of the presentation, which should last for about an hour or so, so bear with us. Now, within the chat box, you have a couple options. You could either send a chat to everybody in the group, or you could send a private message to me specifically. So the way that you will be able to distinguish is by typing in the chat box. You'll see a blue bubble. On the blue bubble, it will say everyone, which of course signifies you will be chatting for everyone to see. If you would like to send me a private chat, go ahead and click that same bubble, scroll to my name, Andreas, and then send me a private message. Really quick, I'm gonna type a chat just to get the whole chat started. Make sure it works for everybody. I'm gonna type my name, and I am going to type where I'm tuning in from. Let's see. If you guys could all do the same, I'd appreciate that. Make sure we could all have our chat working today. So there's mine, Andreas and San Francisco. So I'll give you guys a few moments, just type in your name and where you're tuning in from so we can see where everyone is and make sure the chat's working. Awesome, we got a few people already. Excellent. So now that we're able to properly communicate with each other, I would like to introduce today's presenter. Jay Greene is the founder, attorney, and CPA of the Greene Estate, Probate, and Elder Law Firm. Jay has been practicing law for over a decade, and he is licensed by the California, Alabama, and Florida bars. Jay has a specialization in asset protection, in which he provides a variety of wills and trusts to meet all of our clients' needs. This is done with a main focus on veterans benefits planning, Medicaid planning, and Medi-Cal planning. So today, Jay has extended his expertise to all of us and has allowed for a live workshop that we are all on together today. So without further ado, I would like to introduce Jay Greene.
Thank you, Andreas. Thanks so much for everybody for joining us here today on the workshop. Really appreciate you taking time out of your day. I know we're kind of all going through a little bit of a crisis and we are kind of adjusting to a new normal. So a lot of us now are at home, so where we may not typically be. So it's just gave us the time to kind of focus on what's happening with us and then just making sure that we have plans and we're ready no matter what's happening. What I wanted to do for all of you was to set up the a presentation just to give you an idea of kind of what you need for estate planning and where you start. So the presentation today is the 3 easy steps to estate planning. So we're going to let you know what you can do to make sure that you're ready no matter what happens to you. So what I want to do is just go over an agenda of how the meeting works today, so you'll kind of understand where we're going. So for the agenda, we'll talk a little bit about my backgrounds, just so you understand a little bit about me and what brought me to estate planning. Then we'll kind of identify what all you want to know. So that's why I had Andreas go through the chat function with you. Some of you probably came here today with specific questions you want to make sure get answered during the presentation. So a lot of those questions we will be answering as we go along today, but I also wanted to make sure that you had the ability to ask those questions during the presentation, and then at the end we'll take more questions if there's more. We'll also discover the 3 steps to protect you and your loved ones. What we're going to do too is at the end, we're going to do an evaluation, because it's always very important to me that when I'm speaking, I know how I've done. So what I would like to do is just do an evaluation so that you can kind of tell me how I've done. Andreas will send you a link at the end so that you'll be able to go in there, let me know how you thought I did, and also if you're interested in moving forward with us. So that's what we'll be doing, is giving you an idea how you can create your action plan. So a little bit about me. I'm Jay Greene. I'm an attorney and CPA. I've been practicing estate planning law for over a decade. Andreas is going to put some links in the chat box. The first one is just so you'll have the link to my law firm's website, so that if you want to go and pull out a little bit more information about some of the things we talk about, it's going to be there. It's also a resource for getting in touch with us, scheduling some appointments that we'll talk about later. The next attachment is the law firm vision statement. These are kind of summaries, because we're going to go over a lot of information today. So what we want to do is make sure you have a resource that you can go back to later. So when you're thinking about what did Jay say about powers of attorney, what did Jay say about wills, what did Jay say about trust and the difference between revocable and irrevocable, you're going to have this as a reference sheet that you can go back and use later. So you're going to have those 2 resources to get in touch with the firm. One of the things I want to do is talk a little bit about me. As you might can tell from my accent, if you haven't met me in person already, I'm originally from Alabama. So I started the law firm in Alabama. I'm licensed to practice in multiple states. And I was obviously raised in Alabama. Family is very important for us in the South. Making sure that our loved ones are connected. Kind of what I saw as my grandparents aged is some of the stresses brought to my parents when my grandparents didn't have proper plans in place. So seeing those stresses as I went through life has actually enabled me to focus and be able to give clarity to other families, make sure that they're more protected and that they're not going to have issues arise for them. My education, I have 2 accounting degrees, have a law degree, and I'm also a CPA. All of that factors in to me being able to help people structure and do more comprehensive planning. Not everybody's families are the same. Not everybody's financial situations are the same. So we don't want people that's just trying to throw you into a box. We want to make sure that you're protected no matter what's happening. And that's what I kind of use my skill set to do. I always want to make sure my value, I think, is in helping people. helping people reach their goals. We all have goals in life and what we want to achieve, and we need to make sure that the plans we put in place are actually going to achieve our goals. And that's why I do this, is because I want to help people and make sure that they're protected no matter what's happening. So typically, if I'm doing a live workshop, I'll actually open it up for questions. So, but right now I do want you to think, and if you have a minute and you have something, you know, I wanted to make sure this got covered today. I've always wondered this about estate planning. Now's the time you can submit those questions to Andreas, and then he's going to be going through those questions with me at the end. Some of those we'll just briefly summarize because we're covering it during the presentation, but we will hit all those questions up at the end because I want to make sure that this was a valuable use of your time and that it was helpful for you. So I want you to come out with the answers that you need. Some common concerns that a lot of people step into my office with is kind of what happens if you become disabled? Who's going to care for your children if you become disabled? Who's going to care for you, and who's going to make decisions for you? Who's going to decide what happens with your property? Who's going to make sure that you're okay and that your property is being used for you and your loved ones? If we have single children over 18, how do we make sure that we have some authority over them if something happens to them? If we need long-term care, or we have parents that need long-term care, how are we going to be able to afford that? And how do we make sure that we're planning responsibly? What's my risk about getting sued, and how do I protect from those risks? How do you keep your affairs private? And then what happens to you if you fail to do any type of planning? So, goals of the workshop. You want to identify if your current plan meets all your goals. So if we go through today and you think you have it all figured, all set in place, then you're all set. Maybe you don't need to do anything. But what we want to do is understand what it takes to protect you and your stuff. We want you to anchor to some of the stories that we're going to tell you today. We're not necessarily wanting you to learn all the legal rules, but we want you to understand what your risks are and how you put plans in place for them. So then we want to just let you know what's missing with your plan. So if you have a plan currently, but you don't have some of the resources for these stories, what can we add to it that's going to make your plan comprehensive and set? So now let's start thinking about these 3 steps we're talking about to plan and protect for you. So the 3 steps, and we're going to go over each of these in more detail. You're going to want to know the rules because you can't really plan if you don't know what the rules are that you're planning around. You're also going to want to know who your predators are. When we're doing the estate plan, we have to decide how we're going to structure it so that we're protected from these predators. So you have to know who they are so you can protect yourself. And then knowing your options. So we're going to have different types of options for estate planning. So once we know what the rules are, and then we know who our predators are, then we can pick the best option that works for us individually. So the first thing is knowing the rules. So what it is the government has rules when you're alive and after you pass away. So you need to know and understand what those rules are so you know what the plans are. So the government rules during your lifetime, if you become disabled, what's going to happen with you. So when you're alive and well, obviously you make all your decisions and you determine what's happening for yourself. But if you become disabled, then what are we going to do with you? So it depends whether you decided to put any type of planning in place. Some people do minimal planning, which is going to be good as a starting point for your planning. That you would want some disability documents to provide for you. You would need somebody to handle your legal and financial affairs. You would need somebody to pay your mortgage, pay your rent, have access to taxes, other things that need to be taken care of. That document's going to be a power of attorney. So that's going to allow somebody to make legal and financial decisions for you. The problem, if you do just a base power of attorney, is sometimes that's kind of broad and it's all at once. We're going to talk in just another slide or two about what some of your different options are. Then we talk about a healthcare directive. A healthcare directive is for your medical decisions and who's going to make medical decisions for you if you can't. So there's kind of two components to a healthcare directive. There's a healthcare proxy, which is controlling what's happening to you at your end of life. But then there's also a living will where you're giving them a set of instructions about what you want to have happen. So again, we'll hit that in just a little bit more detail in just a second about what's in base documents versus what's in more comprehensive plans. Also, the state has rules in place for you if you don't put any of that in place. If you don't have planning, then the state will do a legal guardianship of you. With that, though, it's more complicated because we didn't put somebody in control to make decisions for us. So we're going to have doctors signing off saying that we're incapacitated. So we're waiting for that. So there are time delays by going through this proceeding. And then it's all court hearings, it's government supervision of everything that we need done versus us just picking somebody that we want to handle it and letting them move forward with it. So then the government rules after death. With base planning, we talk about a last will and testament. That's go name who's in control. We've picked this person if we're doing the planning, so that's going to be our executor is in the will. So that's who's going to control how this gets to everybody. Who gets your stuff is your beneficiaries. So you can name whoever you want to receive your stuff in your will. The thing that a lot of people don't remember, and we're going to hit this multiple times today, is that a will does require probate. So it is a government process. So you can somewhat lose control because you're doing, the government's over the process and you and your loved ones are not in control of the process by themselves. So what if you don't have these in place? So if you don't have anything in place, then the government has a plan for you. It's called dying intestate. It determines who's in control of you, which is an administrator. So that administrator may not even be somebody you know, somebody you trust. It could just be somebody appointed by the court. So that kind of takes control away from you and your family. So who's going to get your stuff are your heirs. So your heirs are the people that are your loved ones, your relatives, that the government's decided should get your stuff. This causes problems for some people because they're not that connected to their family and they don't want the government dictating who gets it. The other issue with our heirs is we don't necessarily know who those people are. We know who we think they are today, but nobody has heirs until the day they die. So we don't know if we have minor heirs. We don't know if we have disabled heirs because we don't know what everybody's condition is going to be on the day that they die. So that can make our process more complicated and it can cause extra complexity for our loved ones. So that's why we don't want to die without a plan because we're putting plans in place for those people. This is still going to require probate, so it's still a government process. It's a little bit more complicated when we don't have a will, and it's a little bit more expensive when we don't have a will. So that's why we want to try to avoid it, and we at least want base planning in place. So just to reiterate this fact, a lot of people in California, because trusts are a little bit more standard out here, and probate's high, but in other parts of the country, sometimes they don't understand that a will still has to go through probate. So if you own stuff in your own individual name, then it's going to go through your will. And your will has to go through probate. So then when we talk about probate, we're talking about an estate administration. That's another name for it. So in that process, we're going to validate your will, we're going to pay your debts, and your assets are going to be distributed according to your will. It's the only legal way we can change title to stuff owned in your own individual name. So some problems when we have to go through probate is that the court interprets your will. So even you could have intended for one thing to happen, maybe a judge, maybe some of the attorneys in the proceeding actually interpret differently than what you were necessarily wanting to happen. It can be easy to contest because all an heir has to do is just not respond back to contest the probate. It can be expensive. In California, it typically can range between 3 to 5% of the state. That's statutory fees. That's true in a lot of other areas because the probate costs are so high versus us transferring it with other options. The other thing is time. We have to leave the probate open for creditors to respond back. And then we're subject to the court caseloads to get the probate closed. Many times this can be 9 to even 2 years if you have some complexity with creditors in this state. During that time, the heirs really have no control over the assets and what's happening to the assets. So we want to make sure that our heirs can have the resources they need. If we're supplementing for children, if we're supplementing for parents, we want to just make sure that they have the resources they need to move forward. The other issue is that there's no privacy. There's public notice, and it goes out to all the creditors. So we're not really protecting our loved ones. If we're leaving them all of our money, whether that's in investment accounts or whether that's real estate, is going to be available to everybody. So what we want to do is make sure we're putting plans in place that make sure that our estate is private. So what I like to talk about in my firm is the distinction between having documents, or what I would call just a sheet of paper, versus having planning, something that's going to help you accomplish your goals. So when we're thinking about the power of attorney, we're thinking about the difference between just having a document and having a plan. So if you have a power of attorney, it's similar to like a blank check. So if somebody has a blank check from you, what can they take? They can take everything that's in your bank account. So we don't typically want to give somebody a blank check because we don't want them to take everything that's in our account. But that's what some people are doing with a power of attorney, because they're giving the power of attorney to somebody with no set of instructions about what's supposed to happen with the money. That's what we call a super blank check, because they can not only take everything that's in your bank account, they can take everything that you have. So what we want to do is make sure that there's some restrictions on our plan, that it's tied to our estate plan, and it's being used for us and our loved ones as we're kind of noting in our plans. The other problem that you have is it really enough authority? How do you have full authority for the power of attorney to do everything they need to do to protect you and still restrict it? That's when we want to make sure that we're giving them the ability to do trust planning. I have a lot of clients come into me wanting to do trust planning, and the powers of attorneys that either maybe they've done on their own or through a different firm actually don't give them the level of authority they would need to do that type of trust plan to protect them if they're needing long-term care or asset protection. So we want to make sure that we have a good comprehensive power of attorney that's going to be tied to our estate plan, but also gives us the ability to take the types of actions that we might need. Also, we want to think about the healthcare proxy. So that's the God power. If we die right now without a healthcare proxy, we're allowing the state to determine whether we live or die without any set of instructions from us about what we actually want. So what we want to do is make sure that we've given a clear set of instructions about what we want to have happen. The healthcare proxy is going to be a person that we name to make medical decisions for us. So if we just name a healthcare proxy and don't give them a set of instructions, it's going to be really confusing about what we actually wanted, and we're putting a lot of what should be our decision on them. So what we want to do is make sure that we've given a living will that says what we want, if we're terminal, comatose, vegetative, whether we want food and hydration. We want to give a healthcare proxy the ability to step in and potentially make decisions different from us. And then we want to make sure that we have a very comprehensive healthcare proxy that has information about our organ donation. It's got the ability for them to receive the medical records they need. And what happens if we're not terminal, comatose, or vegetative? What do we do with us then? We want to make sure that we're given a very detailed personal care plan about how we structure our day-to-day lives. What I say is we're just writing out what we like to do on a day-to-day basis now, and we're making sure that that is available to the people that have our money. That's going to be our power of attorney or successor trustee, and then they can use that money for us. Lastly, we have a last will and testament, and it's very good to have one, but it's not a comprehensive plan because you still have to go through probate. So you understand that you're still subjecting yourself to the government control. So we're going to talk about some options to avoid that. So when we're thinking about one of the next things is you need to know who your predators are, because you can't really plan if you don't know who your predators are. So when we're talking about that, we're thinking about the government, we're thinking about long-term care cost, we're thinking about your family and how they become predators to you, and we're thinking about lawsuits. And how do we protect ourselves in each of these circumstances? So when we're talking about the government, it can become predatory if we don't put plans in place for ourselves. It can get expensive for us. So from the guardianship side and the probate side, we were just talking about some of those things. Both of those are subjecting ourselves to court control. With a guardianship, you're subjecting your own physical body to government control. So what we need to do is make sure that we have base disability planning documents or more comprehensive disability documents that's going to make sure that we don't end up in a guardianship proceedings. Also, we want to make sure that we don't burden our family within probate court, because there's not only the financial cost of going through probate, it's the emotional, it's the personal cost, it's the inner family conflict. So what we want to do is make sure that we're putting a good comprehensive plan in place for us so that no matter what happens, our family has a clear set of instructions about what we wanted. We're not subjecting them to government interference into our own family, our own loved ones' lives. And lastly, we always want to think about taxes and planning around taxes. The state tax limits are pretty high. There's people in San Francisco and some others in other parts of the country who have estate tax issues. So, but the fact that those limits are so high now, it's almost 11 million for an individual. Couples can plan and almost double that. And even when it goes back down, maybe in 2025, it's still over 5 million for individuals. So a lot of people don't need estate tax planning. But what that has done is opened up the door to other types of planning that can work for you and your family, such as asset protection for beneficiaries. So now's a great time to be thinking of what types of plans you can put in place. In California, we're always worried about protecting property bases and transferring property. So we want to make sure we do stuff in certain ways that keeps us protected no matter what. So one of the other big costs are long-term care costs. How are we going to afford long-term care costs? Those costs, of course, vary, and it depends who's doing the cost. Ideally, you know, we all want to stay at home for as long as we can, and we want to remain as independent as long as we can. When we can't, then we want to stay at home for as long as we can. And as you can see, in-home care costs can go up incredibly, especially if you get to the point where you need 24-hour care and there's more medical care. The cost can get fairly enormous. Then when you move from there to assisted living, you're picking on other additional costs. So what you want to do is make sure that you're kind of planning so that you'll have enough money to stay at home for as long as you want to. Then when that's not as feasible, you can go to assisted living and they'll be able to assist you to make sure that you're safe. And then you have a method to know that you can pay for nursing home care if you need it. There's different benefits that we can plan around when we're thinking of those, but you just want to make sure that you're protected no matter what's happening. So you want to think about what type of care I might need in the future, and then how am I going to pay for that type of care. So when we talk about who's going to pay for care, it's always typically three people. Either you're going to have a long-term care policy that pays for it, you're going to privately pay for it, or the government's going to pay for it. So in what order does the government pay? The government pays last. So what we want to do is think about how are we going to cover that? Are there Medicaid benefits in the future that we could use? Do we need to plan for Medi-Cal, which is California's version of Medicaid? And then thinking about, am I a wartime veteran? Are there resources available to me from my service in the war that I could use to pay for that care? What we have to think about is planning for the transfer periods when we do this, and trust planning. So some of the questions that come up when people think about Medicaid is that they're going to come and take your home, that you have to give away your assets to protect them, and that you have to give away your assets and you have to have done that 60 months ago to qualify. None of that's completely true. And the rules are very complex and they differ from state to state. So when you're thinking about long-term care and what your options are, you want to make sure that you know what those rules are in your state. Since this is a national presentation, we're not going to go into specific state rules today. But if we're thinking about long-term care planning and how you're going to afford long-term care planning, then what we'll definitely do is, if you sit down with an initial consultation with us, we'll go through and figure out what resources are available for you and how you might use your resources to pay for care, and then plan for the future. So then another thing we think about is unanticipated predators. So we can end up having unanticipated predators. Our family doesn't intend to be predators. Our family does not want to go through the state that we're leaving them or put it at risk for other family members. So we like to call those unintentional predators, because sometimes people do stuff in their family that causes some unintentional consequences. And how are we putting plans in place to make sure our family's protected even when these unintentional consequences are there? So when we're thinking about that, what would cause those types of issues? So in your family, it might be that there's a spouse, there's a blended family, there's been a remarriage. So when we remarry, how do we make sure that our spouse is protected, but also that our children still inherit? If we pass away before our spouse, how do we make sure that our spouse is protected, but they don't leave our half to the new spouse? So these are plans that we can put in place in our document through trust provisions, whether we do wills or trust, to make sure that what we're leaving gets to the people that we intended to. Next, let's think about our children and our beneficiaries. What happens to them? If we just leave all the money to our children, our beneficiaries, the people, our loved ones that we chose that we want to inherit, how do we make sure that they're protected? What if they're a spendthrift? What if you give them a nickel and they spend a dime? What are we supposed to do with them? So do we want to give them all the money at once? Probably not. So we can set up trusts that protect them, so that they are not going to lose all this money right away. We may also have children that have bankruptcy issues. We may not know what's going on with their children or heirs, whether that's nieces, nephews, to know what's happening with them. So what we can do is leave what we're leaving for our loved ones in an asset protection trust. And that will be protected to them no matter what happens. So if they have a bankruptcy issue, they're not going to lose it in the future. We can also do planning for addiction. So probably the quickest way to unfortunately kill somebody that has an addiction issue is to give them all the money at once. So what we want to do is make sure that we're not doing that in our plans, and that we're setting up trust planning that's going to make sure that we're providing resources to our loved ones that have addiction issues, but we're not putting them in a situation where they could hurt themselves worse. And then thinking about disabled beneficiaries. If we have a disabled beneficiary, or because we don't know what the condition of our heirs will be in the future, we may have a beneficiary that becomes disabled by the time we actually pass away. How do we make sure that they're not going to lose their government benefits? How do we make sure that we're structuring it so that their Social Security, their Medicaid, that their HUD housing is protected? How can we set up trusts that protect them? What if we have divorces? We're wanting to leave stuff to our loved ones, whether that's our children, our nieces, or nephews. We're not necessarily trying to give it to our in-laws. So what we want to do is make sure that our children, our loved ones are protected, so that what we leave them is protected no matter what they may have going on in a family dynamic. We don't want an in-law staying around just for our beneficiary to receive an inheritance and then divorce them as soon as they receive it. Also, when we look at financial aid and planning for loans and grants for children, we want to make sure that we're not messing up the planning for our grandchildren and their college futures. One of the next predators we want to think about is lawsuits. So we want to make sure that we can put plans in place to protect us if we get sued, so that we have asset protection and we're not going to lose everything we have just because somebody sued us. Do people get sued? Of course they do in the US. Is it expensive? Yes. So what we want to do is make sure that they're protected. And just as we could have the same issues with getting sued, so could our beneficiaries. So we want to make sure that our beneficiaries are protected no matter what's happening to them. So one example I wanted to give is a lot of people own property jointly, and they may own it with their spouse jointly. So, you know, in that situation, we have a spouse, Bob and Sue, they own the property together. Sue passes away. So then what happens? Bob ends up with the property. Then Bob remarries down the road. Nothing wrong with that. Everybody needs somebody to love them. So we're not mad at Bob for getting remarried. The only problem is that Bob has now added Sylvia to the property. And now when Bob passes away, Sylvia is the owner of the property. So, and this happens many a times with families, it all ends up going to Sylvia's kids. So what happens to Bob and Sue's kids? What happens to Sue's kids? They ended up with nothing. So sometimes we think we can avoid probate by using beneficiary designations, by using joint ownership. I don't actually need to have an estate plan because I can do all that. But what happens is our loved ones don't actually receive it down the road like we're planning on them doing. So what we want to do is make sure we have a comprehensive plan. So we don't want to just avoid probate. What we want to do is properly avoid probate. We want to make sure that it's getting to the people that we intended it to go to. So the last step now is we need to talk about what our options are. So we're going to go over estate planning a little bit. We're going to talk about some of the core elements of a good estate plan. That is talking about who is in control, who's going to benefit from that plan, and when will they benefit. What happens when you're alive and well? What happens when you become incapacitated? What happens when you're deceased? How does that change when your spouse becomes incapacitated? What about if your spouse remarries or if your spouse passes away? What about your children? What if they're get a divorce? What if they're disabled? How are we putting plans in place that make sure no matter what's going on with our family now and in the future, that our plan is going to work? So the definition of estate planning, and this is what I kind of like to tell a lot of people, is I want to control my property while I'm alive and well. I want to plan for me and my children and my loved ones if I become disabled. And I want to give what I have to whom I want, when I want, the way I want. And we want to do all of that without becoming a burden or by causing unnecessary cost or delay. So what we want to do is make sure that we have a proper plan in place that's going to protect us no matter what's going on, and also making sure it's not going to be expensive and it works the way it was supposed to. So that's what we call proper planning. So almost everybody wants to stay in control. You want to be in control now. If you become disabled, you want to be in control. And when you pass away, you want to know that your wishes are being carried out the way you want it. You also want to not become a burden to your loved ones. You want it to be easy for them. You want to keep it simple for you now while you're doing the planning. You want it to be simple for somebody to take care of you if you're disabled. And when you pass away, we want it to be simple to transfer your assets to your loved ones. So when people do planning with my office, we make sure that you know the difference between having documents, just a sheet of paper, and actually doing planning, which is going to accomplish your goals. We want you to understand all the costs, and that's not just the cost of creating a plan now, that's the cost you subject yourself to later when your plans doesn't work. And what we want to do is make sure that you understand how to minimize all of those costs, both financial and personal, so that you and your loved ones are protected to the fullest extent possible. We want you to know what your options are, and then we want you to choose the plan that's right for you. Everything with estate planning is a personal decision, and it should be you deciding what works best for you and your loved ones. So option number one, when we think about the planning and what we can do with the planning, is we could do no planning. We could let the government have control. And the government has plans in place for you. And you may not like them when you're in the middle of those plans. If you don't put any plans in place, all of those plans are going to require court proceedings. So if you're disabled, every decision about you will be made by the court. If you pass away, the court's going to set up that intestate proceeding we talked about. It's going to be more complicated, and it's going to take longer. We could do minimal planning. And with minimal planning, that means that we want to make sure that there's a set of instructions. We want to decide who's in control of us if we're disabled, if we pass away, and that we want to name who's our beneficiaries and not let the state determine. And that's a good plan. That's a good plan for a lot of people, but it may not be right for you and your family if you have a little bit more sophisticated situation going on. The problem with that plan is the court's still supervising you. So anytime we get the government involved, it gets a little bit more complicated, it gets a little bit more time consuming, and it gets a little bit more costly. What we would think about then is, do we not want the government involved in our plans? Then another option we have is we can do a probate avoidance plan to make sure that the government's not going to be in charge of us. The only problem is if we do base level planning at that, we may not actually be protecting us and our loved ones from all the issues that may come up in life, whether that's asset protection planning for our beneficiaries or for us. So another option is that you can create your own custom rule book. So how do you create that rule book? How do you have it be your voice and have something that actually works for you? In my office, we do that type of planning through a trust. So we would make sure that we're creating a comprehensive trust that is personalized to you and your loved one's situation. It's going to make sure that we integrate all of these rules with your life, and it makes sure that it's integrated into your assets you hold so that you're protected no matter what's happening in the financial markets, in your medical condition, in your family situation. Everything's going to stay protected. We want to also make sure that we're maintaining your rules, and that as your life changes, as maybe you decide you might need to change a trustee, change some beneficiaries, you have the ability to do that. If you don't do all three of those things, then normally your plan's probably not going to work for you. It's going to become ineffective at some point in time. So what we want to do is make sure that we're maintaining our plan and that it's always going to work for us. So what I'm going to kind of talk about a little bit is the distinction between good marketing and good lawyering. So good marketing might just be doing your typical trust. It's really just documents. It's not necessarily your rule book about who gets what, when they get it, how they get it, are they protected. It's typically still going to require a lot of overview by doctors as far as successor trustees stepping up and taking action for you. The probate avoidance is only going to work if we fully integrated your plan with your life, which means we've retitled assets and changed it so that your trust is owning stuff. It's also outright distribution at death. So that may not protect your loved ones the way they might actually need protection. So what we like to think about doing is a little bit more good lawyering. We want to make sure that you have personal options, that you go out and you don't just talk to an attorney and they tell you, we do that. Because we want to actually walk in there and understand what they're doing. And are they creating a personalized disability rules for you and instructions that are not going to require court proceedings for your estate plan to take place? They're not going to require medical oversight for your disability instructions to take place. You have created your own instructions that works for you in your time when you need it. Also, when we think about asset protection, we want to make sure that we're protecting stuff. There's always changes in the law with IRA planning, with the Secure Act, legislation changes that we need to make sure are incorporated into our plans. Then spousal planning. If we give our spouse $1, what can they do with that $1? They can do anything they want to. So what we want to do is make sure if they can do that, that means their creditors can too. So they're creditors and predators. So what we want to do is protect that for them. So instead of just giving them that $1 directly, what we can do is put that $1 into a box. And then that box is protected for them. So that if they have creditor issues, if they have predator issues like nursing homes in the future, that box is still going to be protected and that money's available for them. So that's what we can do for our spouse. And then for the children and for beneficiary planning, we want to make sure that they're protected no matter what. If we have children and we're leaving them our condo, maybe instead of leaving our daughter the condo directly, and then her partner runs off with the pool boy, we're not worried about the pool boy ending up with a condo we just left to our child. What we can do is structure it in such a way that it's in this asset protected trust for them, so this closed box, so that if their spouse runs off with the pool boy, that we make sure that their spouse does not go end up with a condo, that condo stays in our family and it's protected in our family no matter what happens. So that then our children are protected, our grandchildren are protected, all of our loved ones that we're leaving stuff to are protected. So misconceptions of trust is some people think you have to have a lot of money or assets to do a trust. Some people think you have to be old. Some think you need to have children. A trust is just a document that we use to plan for your life and your future. A trust is a disability document. It is a document that works during your life. So it's going to work right away if something happens to you and you become disabled. So, and we're making sure trusts are very customizable. So we're making sure that you are protected no matter what's happening. So having a rule book is the first step. Then you need to integrate your rule book. So if you're walking through life and you have your house, you have your stock, you have your bonds, and you're just holding those, if something happens and you pass away, what is going to happen to those boxes? They're just going to fall to the ground. If you're disabled, they're going to do the same thing. If you have a power of attorney, they can come and pick those up. If you have a will, it's got to go through probate, and the executor is got to be appointed through court to come pick those up. If you have a trust, instead of you holding all these boxes in your hand during your life, what happens is we take all those boxes and we put them into your trust. So we put the house into your trust, we put the stock and bonds into your trust, we put your bank accounts into the trust. That's this little red wagon. So if you're walking through life and you have all those boxes in your little red wagon, what happens if you become disabled or die? What happens is that those boxes don't hit the ground because they're still safe in the trust. So then what's happening is the only thing that hit the ground was the handle. The handle is your set of instructions about what you wanted to have happen to those assets, who you wanted to go to, when you wanted them to go to, how you wanted them to go to them. That's what a trust does for you. The person that's going to come and pick up that handle, that's your successor trustee. So they're going to have this full set of instructions about what you wanted to have happen to your stuff. If you're disabled, how you want your money spent on you. That's what we're creating when we create a plan. So that's why it's very important that we title your assets into the trust and that they're going to be safe. So then we talk about, what about joint accounts, beneficiary designation, payable on death accounts? They avoid probate, but the problem is they're not integrated into your plan. So we're having a comprehensive plan about who's going to get your stuff and how they're going to get to it, and making sure that we protected them with some subtrust planning. We have to name that to your trust so that it's protected. So when you're working with a estate firm like mine, what we're doing is helping you to make sure you're designating stuff correctly so that this comprehensive plan you put in place works for you. So option 3, when we're looking at doing planning, is asset protection trust. So the other trusts provide protection for your beneficiaries when you pass away. If you need asset protection for yourself during your lifetime, then we're looking at doing an asset protection trust for you. It's going to start the benefit clock running when we do this trust. That's whether we're looking at veterans benefits, if we're looking at Medicaid, Medi-Cal benefits, then what it's going to allow you to do is when you actually need care down the road, it's going to make sure that this money is protected for you and you have supplemental money so that you have a good quality of life like you were expecting. Some disadvantages to this is that you have to give up the control of the principal directly. This is just through a lifetime principal beneficiary. So what we like to call it, it's like a trap door. So what you would do is, this is somebody you would have in your family, a loved one, a close friend, that you would just have them there if you actually needed the money. You typically don't need the money because you're living off income, which you have access to, and you are you're letting the principal grow because that's your retirement. So you're typically protected in that element, but it makes sure that if you need it, you can get it through these lifetime principal beneficiaries. You can change these people. You still maintain all the control because you're the trustee. So if we're looking at kind of long-term care planning for benefits, or if we're looking for asset protection planning for business owners, rental property owners. This is definitely a plan we should at least have conversations about when you come into your initial meeting with me. So some of the benefits, again, for the asset protection trust, it can give some protections from divorce. It can give protection from future predators and creditors. That includes the nursing home clocks. It starts the benefit calculation clocks going, so that then you know, if I want to go ahead and use my money towards home care, if I want to go ahead and move into assisted living, I can confidently do that because I know I'm going to have resources later if I need skilled care. It also protects against family indiscretions. So when we think about the costs, what are the costs if we don't do anything? There's the cost of probate, so it gets expensive. The base minimum out here is 3 to 5% is what you're looking for. It's probably going to be a little bit higher than that. The delay can be long. A lot of times we're looking at least 9 months by the time we get creditor and the court dates. That's the public filing, so it's the lack of privacy. And then we have to notify all of our heirs. And some of us are not really in a position where we want to reach out to our legal family. We also have the issue is maybe our spouse blows the money and there's not money there for our heirs, our children, our loved ones in the long run that we had planned for. We also don't want to give stuff to our heirs directly and then they blow or lose that money. We're wanting to make sure that we set up a structure in place so they're protected no matter what's happening to them. And then the cost of nursing home costs. When we start looking at long-term care costs, we're probably starting at about $6,000 a month and it goes up. So we're looking at hundreds of thousands of dollars that we're going to have to pay towards our care. So we want to make sure that we can plan and that all of that's not coming out of the money we worked to accumulate our whole life. So you also need to maintain your plan. So if you have a plan in place and you feel like you're all set, you need to make sure that your plan stays current for changes into your family, for trustee, executor, agent changes, and then when there's changes to federal and state laws. And there's actually been some that impact all estate planning. So you need to review those with your estate planning attorney or office like mine. So how do I protect my stuff in 3 easy steps? You need to act. You need to assess your needs. You need to create what's missing, and you need to tie your plan in with your life and integrate it. So one of the ways you can do that is you can book your appointment with my office. So there's going to be a square link that Andreas is putting in the chat function. So with that link, you'll be able to schedule either a 30-minute phone consultation, just have an initial consultation, or we can do a full hour-long vision meeting. In that meeting, we'll anchor back to some of these stories we talked about in this workshop so that we can discuss kind of how those tie into your estate plan. Also, what we'll do is we'll talk about your family in specific and how we envision a plan might work for them. And then lastly, we'll go over some options for you. And if you want to move forward with planning, you can do it at that meeting. So again, I said that's a free consultation. It's a video or phone, and you can sign up for it via that square link that's in your chat box now. Like I said, we'll find out the plan that's best for you, and there's no obligation if you sign up for that meeting. If you've enjoyed this presentation too, definitely feel free to reach out, let your loved ones know. They can reach us at Greene Estate, Probate, and Elder Law on Facebook. Our website, Andreas put in there, is assetprotectionbayarea.com. One of the things we also want to do, because I said it's definitely important to me, is to know how this was. I hope you found this to be fun. I hope you found it to be informative, and I hope you thought it was a very good use of your time. And I hope the options on the evaluation reflect that. It's a SurveyMonkey link that Andreas is putting into the chat. It's a very short survey. It's about 3 questions. If you can just go in and answer those, let me know how you did, things that may interest you today from this webinar, then that sounds good. While you fill out the evaluation, I want to circle back around to the questions we talked about earlier and see if I can answer some of those questions you may have had during the presentation. We're going to let Andreas open up the questions. He'll submit the questions via chat, or the questions that were submitted via chat, Andreas will ask. And then if we need to at the end, we'll open the line and see if anybody else has additional questions.
Great meeting, Jay.
Thank you.
Of course. So we do have a pretty substantial amount of questions. I'll start chronologically from where they were placed in the chat. So the first question was, will we also receive a link to the presentation for future referral? And I'll just answer this question really quick because this is on my part. We will be sending out the video for this webinar because we have recorded it. Additionally, the survey that I put in the chat just recently has an optional question at the very bottom, and it basically reflects this question. So if you would like to refer anyone to us, please list that person's email within the survey. So that is question one. The next question asks, can you explain trusts, different kinds, benefits of each, and what are the steps to setting one up?
So we did go over that during the meeting, but just to recap, we talked about different types of trusts you might want. So we talked about a more base trust that is just going to help you avoid probate. It may not protect your family the way, and your loved ones the way they need to be protected. So what we want to do is decide, do you want that base level of planning, or do you need a more comprehensive plan for your family that protects them no matter what they have going on? And then the last option was the asset protection plans. We can get asset protection for your beneficiaries in that second option on the subtrust planning, but to get asset protection for you, we'd actually need to do a different type of trust. So those are kind of the different types of trusts we do in my office. There are more advanced trusts we do too for estate tax planning purposes. So if you have an estate tax issue, we can definitely talk about those one-on-one. One of the easiest ways to set up a trust is to reach out to my office and then just learn a little bit more about what type of trust might be right for you.
All right, the next question asks, what is a good way to transition a commercial real estate business from parent to children?
Well, a good way to do that is you want to think about the ownership structure of that and how it's currently owned. The good part about trust versus some public entities like corporations, LLCs, is the public nature of corporations and LLCs. It may not be right for your family. And there's a lot of annual filing, regulatory filings with those. If it's owned by a trust, that's a private entity. So you're getting some of the asset protection nature if you do that highest level of trust planning. So you make sure that this is protected. It's protected from everybody's personal assets. But then also you're making sure that it's going to your loved ones in the way you want it to. You can also do that with another types of trust too, but you're not necessarily protecting your personal assets from that business liability, which rental property would be.
Excellent. The next question asks, what is probate, and doesn't a living trust avoid the probate process?
So that is correct. So we did go over that through the thing. So probate was just that process you were going to have to go through if you were intestate or you had a will. So you are correct. A revocable trust will avoid probate either way. So we want to make sure that we're kind of avoiding that unnecessary cost for our family.
All right, the next one, it says, do you need a will if you have a trust? Should each person have their own trust if they are married?
So it's you definitely do need a will if you have a trust, because you could accidentally own something in your own individual name. And what we want to make sure is if you do have a trust, we want to make sure that everything you have is going to be controlled by that process. And we're not going to subject our family and loved ones to a probate proceeding because we didn't have a will. So we need a will that pours over into that trust. For spouses, I think it depends how you own your assets. If you own your assets jointly, or community property, joint trust probably works well for you. If maybe you have maintained separate accounts, or you've gotten remarried and you want to keep stuff separate, then you might want to have separate trust.
All right. The next question is, what should I do if I test positive for coronavirus? Can I even do a trust?
So on that, if you get in a situation where you need planning now, what I want to do is let people know that I'm connected to a national group of estate and elder law attorneys, and we're at the forefront of what's happening with this crisis. Also, I'm connected to attorneys locally in San Francisco and California, and we have talked about how we can meet these needs during this crisis. So there are laws within California that allow us, if we are in substantial compliance with creating a will, if we are complying with creating a trust, then we can do those documents without some of the formalities if the intent is clear. So what I want to do is encourage everybody to get plans in place so that in the unfortunate event that the numbers do uptick, whether you're in another part of the country or the Bay Area, you have a plan in place that's going to protect you now. I think this is very critical for people that's in groups such as the elderly, people with immunocompromised systems, and people that are essential workers. That's our first healthcare responders. It's the muni drivers, it's police officers, it's our grocery workers, making sure that they have plans in place since they're a little bit more exposed because they're seeing more people.
All right, the next one we have is, how does the social distancing constraint impact completing estate planning?
That was similar to what I was just talking about. So it's really making sure that you can get in and create something. So we actually have options so that we will do social distancing now as far as signing to make sure that we are keeping the 6-foot requirements. There can be drive-by signings. We can do signings that are visible but from separate rooms. Everybody using their own pens. And then for people that have more immune type issues, we can actually set up some documents where maybe we're not having to meet in person outside of these meetings like this. So we have Zoom available. We've always had phone calls available. We can do other videos through FaceTime on Facebook. We can use FaceTime like on the iPhone. So there's different things that we can do to meet. So there's multiple things. If anybody is concerned about how they might get documents in place, definitely reach out to me or reach out to Andreas and we can help you get something in place.
All right. The next one is, do you make the trust the beneficiary of your insurances, financial accounts, and properties versus people? Is it different for a spouse?
I would do that typically. Sometimes with community property and some tax issues, we might do planning a little bit differently, but we would still work it out so that whatever our goal of our plan is happening. But we do want to make those beneficiary designations within our trust because we want our trust to be the controlling document. And all these good plans that we're putting in place for our loved ones to make sure that they're protected no matter what's happening to them, we want them to use those plans so that our document so that they're completely protected.
And then the last question, it was just someone's concern about the fact that they don't have kids and they're not married, but they do have a house.
Well, you want to avoid probate. And even if you don't have kids and you're not married, you still have intentions of what you would like to have happen to your stuff. So you'll have other loved ones. So that may be parents, siblings, nieces, nephews. It could just be close friends that you've had for many years. And a lot of people want to leave stuff to charity and they want to make sure that their legacy is leaving on and what they built is going to be available to kind of produce stuff or protect stuff that's important in their lives. So we pick a charity that works for you. So we're wanting to get a plan in place to protect them so that they're getting the highest amount when you pass away. So we're not subjecting it to all these additional probate costs, all these extra attorney fees.
All right, that was the last question.
Okay. I want to thank everybody so much for joining us again. We really thank you for taking time out of your day to come join us, learn a little bit about estate planning. Don't forget you have the law firm vision statement. It's in the chat thing. Andreas will send that out when he sends out the link to the video, so you'll have that resource available both ways. Please don't forget to go and do the survey so that we know how we did today and if you thought the presentation was good and a good use of your time. And then if you have additional questions as we're kind of going through this process and you need to think about your estate plan, reach out to me, reach out to Andreas. You can reach us directly on our website, assetprotectionbayarea.com. You can reach me through Facebook, and look forward to talking with you and make sure that you have a good comprehensive estate plan in place. Thank you again.
All right, thanks everybody. I'm going to end the meeting right now, and I will send out an email with the links from the chat as well as our vision statement. All right, have a good day.
Thank you.